Minister, please, if you would.
Ceann Comhairle and members of the House, I am pleased to have this opportunity to introduce the Court's Establishment and Constitution Amendment Bill 2019 to the House for second stage on behalf of the Minister for Justice and Equality, Charlie Flanagan TD. We look forward to engaging in a constructive debate as the bill proceeds through the various stages. It will be the intention of the Government, for the reasons that I will set out, and of course subject to the conduct of business as agreed by the Houses, that the bill be completed for enactment by the end of June of this year. Following the Government approving the general scheme for this bill in December 2018, the Minister for Justice and Equality referred the general scheme for pre-led scrutiny. In February 2019, the Oireachtas Joint Committee on Justice and Equality decided it was not necessary to conduct such scrutiny, and this pragmatic approach has helped in progressing this compact but nonetheless important bill. The purpose of today's bill is to provide for an increase in the maximum number of ordinary judges of the Court of Appeal from 9 to 15, and it provides for the amendment of the relevant primary legislation in order to achieve that objective. As such, it is a short but highly purposeful bill consisting of just two sections. Section 1 is the substantive provision of the bill. It provides for amendment of the Court's Establishment and Constitution Act 1961 to increase the statutory number of ordinary judges of the Court of Appeal from 9 to 15. Section 2 provides for the short title of the bill and allows for the commencement of the Act by order of the Minister for Justice and Equality. These are standard provisions. As also recalled, the Court of Appeal was established on 28 October 2014 under the Court of Appeal Act of that year. This followed a referendum of the people in 2013, which was passed by over 65% of voters. A key policy objective of the establishment of the Court of Appeal on foot of the referendum was to improve the high appellate capacity of the Irish courts and to alleviate the relevant backlog in cases which had accumulated at that particular time. Appeal cases from the Supreme Court and the Court of Appeal were transferred to the new Court of Appeal, and it commenced the Court of Criminal Appeal were transferred to the new Court of Appeal, and it commenced hearing cases in November of 2014. The Court comprises a President and not more than 9 ordinary judges as set down in the statute. There has been no change in this configuration since the Court's establishment. A vacancy is, of course, in anticipation on foot of the Government's decision of the 2nd of April 2019 to nominate Ms Justice Mary Éireann, whose working contribution as a judge of the Court of Appeal is held in the highest regard to the Supreme Court. The Court of Appeal hears an array of appeals in civil proceedings, as well as in criminal proceedings, and covers a vast array of litigation where parties choose to exercise the right to appeal, such a right being a fundamental safeguard under our legal system. Prior to the establishment of the Court of Appeal, average waiting times for cases to be held by the Supreme Court had increased to over 4 years. For cases on the priority list, the average waiting time was over 9 months. It was anticipated that the introduction of the new Court of Appeal would streamline the administration of justice by having a significant impact on waiting lists, while also making a significant improvement to the overall efficiency of the Irish court system. However, we are now at a point where it is clear from the current waiting times that, without additional judges, the Court of Appeal before too long will be facing similar levels of undesirable delay to those which prevailed in the past. At the same time, I would wish to emphasise that the Court of Appeal and the Court Service have been taking the necessary steps to maximise existing capacities in responding to these ongoing challenges. Case hearing lists in the Court of Appeal are actively managed to ensure that appeals are dealt with as efficiently as possible and that waiting times are kept to a minimum within the resources available to the Court. Hearing dates are now allocated on the first listing of a new appeal, which reduces the administrative work and time for the Court and is, by the same token, more cost-effective for the parties. The need for this bill is not to be underestimated. Information received from the Court Service confirms that, as things stand, hearing dates for civil cases before the Court of Appeal have already been fixed up to and including May 2021. While some allocations have also been made within that schedule so that any urgent appeals can also be dealt with, the time available for civil appeals is essentially fully allocated up to May of 2021. The current waiting time for criminal appeals is 6 months. This compares with the 15-month waiting time which previously arose at the Court of Criminal Appeal and is now generally considered to be at an acceptable level. However, with the exception of certain fast-tracked or very urgent cases, the general waiting time for civil appeals is 20 months. This is considered a significant problem in terms of access to justice. Ceann Comhairle, in terms of existing caseloads at the Court of Appeal, civil cases on hand have risen from 677 cases at the start of Q1 of 2018 to 685 at the start of Q1 of this year. In addition, there are what are described as Article 64 appeals, that is to say, the legacy cases inherited by the Court of Appeal from the Supreme Court. At the start of Q1 of 2018, there were 706 such cases, which had reduced to 242 at the start of Q1 of this year. In terms of criminal offences and appeals, there were 531 cases on hand at the start of Q1 of 2018, with 480 in play at the start of Q1 of this year. Of course, these are not static figures and will fluctuate as cases are referred. in the course of normal courts business to the Court of Appeal on an ongoing basis. Both the current and previous President of the Court of Appeal, the Honourable Mr Justice George Birmingham and the Honourable Mr Justice Sean Ryan, respectively, have highlighted the problems being faced by the Court of Appeal as being most acute and in terms of the Court being overwhelmed by its caseload of both inherited and new cases. The Chief Justice has also fully supports the specific and reasoned case for an increase in the number of judges of the Court of Appeal and has sought the early introduction of the necessary legislation to deal with this as a most pressing problem. Against this background, increasing the number of ordinary judges in the Court of Appeal by 6, as proposed under today's bill, will have a beneficial effect of increasing efficiency in processing appeals in the Supreme Courts and provide a more accessible appellate system with more timely and efficient resolution of disputes for Irish citizens and enterprise. The President of the Court of Appeal has indicated that having 6 extra judges would allow for 3 divisions of the Court of Appeal, one dealing with criminal, the second with the inherited Article 64 cases and the third dealing with the incoming mainstream civil cases. In the view of the judiciary, this would allow for the most efficient disposal of cases, allowing sufficient time for hearing cases in court, reading papers in preparation for court and drafting judgments. The mainstream civil division would frequently sit in 2 courts simultaneously. This would also mean that the President of the Court of Appeal could, as may be considered appropriate, assign a division of judges to deal exclusively with the remaining inherited Article 64 legacy cases. Under such an approach, it may well be possible to clear the remaining backlog of those cases within 12 to 16 months. Clearly, there would be a positive benefit to litigants, as a substantial decrease would be anticipated in the average waiting time for the relevant cases to be heard. The appointment of 6 additional judges to the Court of Appeal is estimated to cost in the region of €1.22 million by way of salaries and allowances. Their appointment would also require the provision of some additional supports by the court service. Funding for such non-pay or capital costs, including any required additional chambers, will be managed within the existing resources of the court's service. As part of the approach being taken under today's bill, it is also intended that the Minister will review the situation regarding judicial numbers in the Court of Appeal in consultation with the President of that Court in 2 years, as in due course the Court clears down its inherited caseload of Supreme Court appeals. Similarly, the long-term requirement for maintaining the existing statutory seating of judges in the Supreme Court will also be kept under review. As recognised by Minister of Planning when he secured government approval for the publication of this bill in March, there is a strong and compelling case for the provision under the bill of additional judicial resources to the Court of Appeal. The Government is satisfied that the additional judicial positions are warranted to address the current demands being faced by the Court of Appeal and to improve efficiency in the appeals process, which is a bulwark of our judicial system and of access to justice. In light of its obvious merits, as I have set out, and of the fundamental importance of the Court of Appeal to the effective administration of justice, Ceann Comhairle, I commend this bill to the House.